the order of violation, so I can kind of update you on it. Give you that.
Yeah. Okay, you're ready over there?
Mhm.
Okay, let me call to order the Town of Loxahatchee Grove Special Magistrate hearing. Today is Wednesday, August 15th. It's a little after 10 a.m. And my name is Bill Doney. I am the magistrate for the hearings. I guess we'll have testimony. Well, I'll wait to swear in witnesses for when Mr. McClendon's here, and we'll do it then. We just have two cases on the agenda. First case is 2010-191, which is Todd and Shara McClendon. We have had a phone conversation with Mr. McClendon. He's on his way, so we will skip that case till he gets here, assuming he arrives before too long. Second case is under the order of violation section, case number 2012-277, property owner Elaine Smiley. And I know from last month we had an order that continued this case, the Smiley case, to today's date, and then what do we have for today?
Thank you, Mr. Magistrate. For the record, I'm Beverly Tu, president of 2 and Taylor, Inc., serving as Loxahatchee Grove's code enforcement. Mr. Magistrate, we had a meeting with the leasee of the property. It was not with Elaine Smiley. The leasee is the property, has a myriad of land uses on this property that the town believes at this point is not in compliance with the zoning districts. As a result of that, Mr. Seth Byers met with us on Monday, this last Monday. And we talked a little bit about the land uses that he has on the property. We're taking a look at those land uses and taking a look at other potential courses of action or recourse that he may have to bring the property into compliance. So with all that being said, he does and did realize that this case was on the agenda today. After we spoke during that meeting with Mr. Byers indicated that his attorney wanted to be present at the code enforcement hearing in front of the magistrate and was not going to be available today. And so as a result of that, a phone call was made to his attorney's office. The attorney for Mr. Byers is not going to be available next month. We all agreed at that point in time that we would come before you this morning and ask for a continuance to the October 17th meeting. At that point in time, Mr. Byers' attorney indicated that he would be available on that day and would be present. With that being said, we made it very, very clear to Mr. Byers that this would be the last continuance. So for the record, in Loxahatchee Code, or Loxahatchee Grove's code enforcement staff, for the record, there will be no more continuances on this case. It will be heard at the October 17th meeting. Just as an update to the case, Mr. Magistrate, so you have an idea of where we're at with this because you've heard me speak of Mr. Byers as the leasee of the property. He has indicated to us that his attorney is also representing Elaine Smiley. We have not spoke to Elaine Smiley. We have not been able to find Elaine Smiley, but apparently Elaine Smiley is being legally represented by Mr. Byers' attorney. And as a result of that, we have made it clear to Mr. Byers that he will need to produce documentation either prior to or during the magistrate hearing on October 17th, which gives him the legal authorization from Ms. Smiley to act on her behalf.
Who is the attorney, do you know?
He was here. Jeff or John?
Jeff Brown, is it?
Yeah, I think does.
I think it's Jeffrey Brown, but don't hold me to that for the
Okay.
record.
Yeah, I'm just curious.
Russ is going to see if he has the card. We've met with him, and again, for the record, we have, in fact, met with, this is the second meeting with Mr. Byers. The first meeting, it was with Mr. Byers and with Mr. Byers' attorney. and I guess for the record, I guess as a recommendation on behalf of the town, Mr. Magistrate, we would recommend that regardless of, or let's say, in the event that Mr. Briers does not produce the documentation suggesting that he is legally authorized by Ms. Smiley, act on behalf of Ms. Smiley, we would like to continue, as of October 17th, continue prosecution of this case.
I don't know if you're about English stuff.
We can get it to you, sir.
Okay, yeah, no, I don't need it.
Okay.
I was just curious as well. That's some time on our hands.
It is,
It is Jeffrey Brown. The firm is Laval, Brown, Ronan, and Mullins, 750 South Dixie Highway, Boca Raton, Florida. And it's Jeff M. Brown, Esquire.
Okay. Mr. McClendon, you're right on time. Well, believe it or not, we're just finishing we're continuing the case before yours. Was there anything else we need to consider on case number 2012-277?
No, sir.
Okay, that being the case, I will enter an order granting the agreed continuance and rescheduling the matter for the October 17 meeting at 10 a.m. And we'll go from there. And since Mr. McClendon is here, we will pick up with his case. Let me just tell you where I think we are, and you can fill me in if I'm wrong, or what the status is. I was looking through my file here and saw the last order. The last order that I see was entered on June 21st, and the order found that substantially the owners have complied with the prior orders. There were some unused cages that were remaining in the setback area that needed to be moved. Also, there was an issue with the shade structure and supporting members on the setback area. Apparently, they're within the 50 feet. Mr. McClendon, at least in June, contended that they were governed by a 15-foot setback, and he wanted some time, Mr. McClendon wanted some time to check that out and see if he could find any OEC regulations. So we continued it. The other matter that would be considered today would be those issues, as well as administrative costs to be assessed. So is there other issues we need to address?
No, sir.
Anything else?
No.
Let me ask the town representatives first then. Have the unused cages been relocated?
Yes, sir. As of this morning, we did an inspection and he is in compliance. Correct, Mr. McClendon? Yes.
Have the shade structure and supporting members been relocated?
No, sir, they have not. And Mr. McClendon did send us some information from the Palm Beach County Land Development Code. It's Unified Land Development Code, Article 4, Use Regulations, subsection, or Section 121, Shade House, subsection A. He also sent us an old aerial where certainly the structure has been there. What I did is I went back and I looked at our code, the Waxahachie Groves Code, and certainly it does say all structures 50 feet. But Mr. McClendon did provide the information. We have not been able to determine exactly when the shade structure was built, but it has been there since the town adopted their municipal code. And based upon the Palm Beach County Land Development Code, shade houses, it states that shade house, a temporary screening enclosure used to protect plants from insects, heat, and exposure to the sun. Subsection A permits, it then says a shade house used for bona fide agricultural purposes less than 12 feet in height shall not be required to obtain a building permit, and it does provide provisions for minimum setbacks, with the structure being 12 feet or less in height, which I believe that it is, 12 feet and less, that the setback on the front and the street is 15 feet and side and rear is 7.5 feet. And I asked Russ to take a look at that this morning, and based upon where we believe the property line to be, it appears that the shade house structure is either at that setback or very, very close to that setback requirement. So as a result of that, we're going to determine that Mr. McClendon is in compliance.
Okay. Now, just so I know, the shade structures are actually shading the birds?
And plants that are in there, in the location.
Okay. Do you have a copy of that code that I could look at?
Yes, sir. And as a matter of fact, you can have this copy. And that's the best, I've interpreted it to the best of my ability.
But the structure did predate town incorporation.
Yes, sir. And what the structure is, Mr. Magistrate, once we took a look at it, if I believed that the structure was inhibiting anything within that easement or that setback, it could be problematic, certainly, and might require a little more research. However, these are, and I have I'll submit this as an exhibit too. The shade structure itself is nothing more. It's a series of pilings that have been put into the concrete pilings that have been put into the ground. The piling, attached to the top of the piling is the actual covering, and it's just the cover. So the bird cages have been moved away from where the piling is, so they do meet the setback requirement.
Right.
But that is a copy of the structure, the shade structure itself.
Okay. Let me just, so the record's clear, I'll admit into evidence this photograph that is dated 8/15, showing the, looks like it's set down the side lot line.
Yes, sir.
The side showing the shade structure and probably that fence that's, as we talked about, sort of near the property line, not sure exactly where it is. Okay.
For us, the property line appears to be, if you, again, look at that exhibit, appears to be they're somewhere closer in proximity to the fence, which has the vine growing on it back behind the small palms and shrubbery there. So certainly, when Russ went out there this morning, again, to the best of our ability, based upon where that setback should be, that he's close to the 15 feet.
Okay. That being said, looks like we're down to costs.
Yes, we would like to present to you, and I guess this would be exhibit 3 now. And I believe that's Alex. We do have an administrative cost summary. I'm going to present this to you as exhibit number 3. We have taken a look at the cost from the time that we started to, from the time that we actually started to investigate this case with the complaint. I'm going to submit this into evidence, exhibit number 3.
Was there an exhibit? The photo was what?
Exhibit number 2.
2. Okay. Was there a 1?
Yes, sir. What was number 1 though?
I don't
Oh,
remember.
exhibit number 1. Exhibit number 1 would be the Palm Beach County Land Development Code. I'm sorry. So we've taken a look at the cost that the town has incurred since January 21st of 2011. Based upon that cost from January 21st, 2011 up through August 14th, 2012, we estimate the cost to be $3,172.50. And Mr. Magistrate, again, just for the record, to kind of show where we've been with this case. It's been around for a long time. We started with working with Mr. McClendon over a year ago, after we received a complaint from his neighbors, Mr. and Mrs. Lefkowitz.
Let me just stop you for a moment. Do you have
Yes.
a copy of this?
I don't.
Do you have another copy?
He may have mine, or actually, yes, sir, I do have another copy. I might need to- We started working with the casework and the correspondence and the complaint, like I said, the beginning of January of 2011. A notice of violation after we worked this case for a substantial period of time and working with Mr. McClendon to assist him with coming into compliance. A notice of violation was issued on June 8th of 2011. So again, even the notice of violation was over a year ago. On 11/16/11, Mr. McClendon came in front of the magistrate for order of violation as a result of some issues that we needed to take an additional look at. That case was continued until November 22nd, 2011, at which time an order of violation was entered. Mr. McClendon at that point in time had 2 weeks from 11/22/11 to move the cages that were closest to the Lefkowitz's property line. Mr. McClendon did comply with that mandate within that 2-week period of time, so he did achieve compliance. However, the remainder of the cages did remain within the setback. We brought back a status update to you on January 11th of 2012. At that time, Mr. McClendon was in attendance. Mr. McClendon indicated that at that time he needed an additional 30 days in order to achieve compliance. Mr. Magistrate, that additional 30 days was in fact granted. The case came back to you for a fine lien certification on March 21st of 2012. Again, at that point in time, Mr. McClendon was still not in compliance, and at that point believed that he needed, in addition to the time that was already provided to him, an additional 60 days to come into compliance. So 60 days was granted to him for him to be able to remove the cages out of the setback. Again, back here on fine lien certification on June 20th of 2012, while most of the cages had been removed from the setback, we did find that there were still some that were within the setback. They are all in compliance as of to date, but as you will find here, we've dedicated a considerable amount of time and attention to this case. So we are requesting that the magistrate enter an order this morning for the administrative cost to be paid in the amount of $3,172.50.
Let me just ask you, the Exhibit 3 represents your time records. Are your records kept contemporaneously with the activity that's performed?
Yes, sir, they are.
And the rate that is shown on here for each individual is the rate actually charged to the town?
Yes, sir, it is.
And has the town paid you?
Oh, I've been paid, yes, sir. They are very, very good about that.
That's good.
Very polite,
Okay.
great client.
Mr. McClendon, you've had at least a moment to look at this. I don't know if you need another minute or two to look at it. What I'd suggest is you can make whatever comments you'd like. Also, if you have any questions about what's on here, I think you're free to ask those questions of the witnesses. And I should add, I haven't sworn anybody in. Let me swear everybody in. Do you swear the testimony you'll give me the truth, the whole truth, nothing but the truth?
Yes, sir.
My first question is Tina Bonyak. Is she here today?
No, she's not.
So there's no way to verify her time.
Yes, sir, there is.
How are we going to verify her time?
Her time is maintained on timesheets that are maintained in my office.
But I mean, I have questions as to what she did during these time periods, and I have no clue as to what she's really done, other than a 4 or 5 word description for a huge amount of time.
Mr. McClellan, what she does, to be very specific with you, is that she is the one who actually puts all of the notice of hearing letters together that go out to you. She does coordination with the town on the certified orders and the minutes. And she puts those notice of hearing packages together with all the copies that go out. Plus, she develops all the exhibits that are prepared and printed and brought to the magistrate hearings.
I understand what her job function is. The fact remains, though, that you weren't with her every minute of this time and can personally verify that she spent this time.
She's an employee, Mr.
I
McClellan.
understand she's an employee, but she's not here to swear that she spent this time. And you can't swear that she spent this time because you weren't with her. Unless you were with her all this time. Were you with her all this time?
I'm sorry, what?
Okay. So she's not here to swear to this time.
No, but if the magistrate needs her here, I can certainly give her a call.
I mean,
But I can
I'm being
time-
charged for a third-party person that's not here that can't say, this person even exists. As far as I know, the magistrate knows,
She's.
this person doesn't even exist.
I think I've seen her here.
Yes.
So I assume she still exists.
Okay.
I mean, we can do it by telephone if you want. I don't
Yes.
think we want to delay this again.
No.
She's available. Were you able to
She's
get her on the
available.
speaker?
Yes, sir.
I mean, some of this time seemed very excessive that she spent. That's how I feel about it.
Do you have something specific that you're asking about?
Well, before you answer that, will she have a copy of this list, Kat?
Yes, sir, she does.
Okay.
Yeah, if you don't mind, if you can get her on your speakerphone, that'd be great.
And while they're making that call, I apologize that I'm not, prepared for today, as I never got any kind of communication really as to today's hearing. Other than the last time we were here, there was never anything put on the town's website with a notice to the hearing. And even talking with Russ this morning, there was a miscommunication face to face. I asked him when the next meeting was, and it was next month, is what he told me. So, there was a serious lack of communication there, so I apologize for not being prepared today.
But if you received the last order, it had the hearing date.
I didn't receive the last order.
Um, Mr. Magistrate, yes, sir. On July 6, 2012, a notice of hearing finding certification was sent to Todd and Sharon McClendon at 3481 dated July 6. It is the notice of hearing, and I'll submit this again. There's also a copy of the order finding partial compliance and rescheduling of that hearing, as well as a copy of the order of violation.
Can you tell me what the date says on there, the hearing on it?
August 15th, 2012 at 10 a.m. And Mr. Magistrate will submit this as exhibit number 4. And the property was posted. Mr. Elgin posted.
Okay, just for the record, then, Exhibit 4 is the notice of hearing.
Oh, and yes, sir, and it's always posted at Town Hall by state statute.
Notice of hearing and other packet of documents is indicated.
It's not on the town website, though.
You know?
Website's not a requirement.
No, I know it's not a requirement, I understand that.
Bear with me. Mr. Magistrate, I do have Tina Bonyak on the phone.
Okay, can you hear me, Tina? Yes, I can. You able to hear Mr. McClendon?
Yes.
We need to gather around. Let me swear you in. Apparently, Mr. McClendon has some questions as to the time you have expended on his matter. So let me swear you in. Do you swear that the testimony you will give will be the truth, the whole truth, and nothing but the truth? Yes, I do. Okay. Mr. McClendon?
Yes, it looks like the first time you worked on this case was July 13th. You have 2 hours there. Review official town files. Can you tell me what that included?
I'm sorry, I can't hear you.
Mr. McClendon, what date was that again, please?
July 13th. It looks like July 13th was the first time you worked on the case. There was 2 hours. It says review of official town files. Can you tell me exactly what you did during that time?
there's no July 13th, Mr. McClendon.
7/13/11.
Is it perhaps 7/3?
There's a 7/13 on
Oh,
mine.
7/13/11, Tina.
What I do when I go over there is I compare the town's official documents and go through their file to make sure that I have everything that I need. If there's any correction notices, notices of violation. So basically just going to the town, taking a look at your file and what transpired.
Okay, give me a minute to look this over. Okay, can you tell me what you did on November 3rd,
What year?
2011?
In preparing the correspondence for the magistrate hearing?
Yeah. Oh, and what's the updated PAPA data?
Basically, I have to go online, I pull information regarding your particular property and make sure that it's current, that, you are the owner, that is the property, UPN number is correct, all of that, and I verify that before I send the correspondence, would be notice of hearing and things like that that I have to put together to mail to you.
There was
I
our,
put the packages together to see what these did, things like that.
there was already a correction notice given at that point. Doesn't that seem like it would be done before a correction notice?
I'm just saying that's one of the particular things that I do when I'm preparing correspondence for the hearing. And also I do, I have to do the exhibits and all of that, file all that information, put it together and copy it and all of that.
Okay, give me one moment. All right, February 28th, 2012. You have 4 hours. Can you tell me what that composed of?
Yes, absolutely. That was going back through from the start of your case and going back through all of our time sheets to file what you're looking at right now.
I mean, I assume you guys keep this log in a file as to the time, so it took 4 hours to total that time?
Well, yeah, because at that point, you're going from the very start of the case and having to go through and pull out the particular time that was dedicated to your case specifically for Ross, myself, and Beth. Yeah, it is time.
Sounds like you might need a better system. All right.
Well, Tom, to run it, you're looking at, over a year's worth of time. And,
Yeah.
and I want to be thorough in that sense, make sure that I make sure to the town as well as you.
Right. All right, give me a moment. On June 6, 2012, you have prepared notice of hearing and certified mailing. That takes 2 hours.
It does, because I have to prepare the notice, and then I have to do all the certified mailing information. I have to go to the post office, I have to mail it. Beth has to review it. And what date was that?
That was June 6, 2012.
Right. And if you notice, there's no time in there for,
Just so you know, this isn't a personal attack, I can assure you.
No, absolutely.
Okay, okay. All right, on June 26, 2012, you have review shade structure issue. Can you tell me how you were involved with that?
Yeah. Basically, we look at what the issue is. We review, the paperwork and the codes regarding those things. So it does, it may half an hour to look through that. And also, I had a discussion with Ed regarding that as well.
We had already been to several magistrate hearings, and according to Beverly, the shade structure was a problem from the initial. Why would it still be reviewing that?
That's not a question that I can answer.
Okay, I think that's all my questions.
Do you have any questions from your
Thank
side?
you, no, thank you, Tina.
You're welcome.
Thank you.
Bye. All right, bye-bye.
Okay, Mr. McKinnon, any other questions of any witnesses or anything you'd just like to testify to?
I just have quite a bit more. There's a total of 17 site visits on here, which seem kind of excessive. There were 4 or 5 of them before the first magistrate hearing. And I know most likely what prompted that is not the town, but a neighbor that won't stop. And it doesn't seem fair that I'm being charged an excessive amount for these site visits because of a neighbor that can't let the town do its job. Seems very excessive. That's my first statement with regard to that. Originally, I was cited for an odor issue, and I'm wondering how much time was spent with regard to that. And since it was dropped at the first magistrate hearing, I would think that I should get credit for that time, since it was time wasted apparently. And in addition to that, the same thing goes with the shade structure. The fact is that the shade structure is legal, and any time that the town spent trying to come after me on that, I shouldn't be charged for it. And in addition to that, there's a Florida statute 604.50 that, since it's originally started, came to my attention that state laws changed. And in all reality, I had no reason to have to move the bird cages, because 604.50 states that any non-residential farm structure is exempt from any local municipal code. And it's very clear, and I don't have that with me. Maybe the town, or you all have that with you.
Exempt from building code, is it?
Any code. Do you guys happen to have that with you by any chance? I know you guys have had it.
Mr. McClendon, no,
No.
and we're not, and quite frankly, we're still of the opinion that you are in non-compliance, that you have.
I understand that's your opinion, but that's not necessarily the magistrate's opinion or a legal opinion.
Then I'm sorry.
But we can't retry the case. I mean, the case
No, I
has gone
understand,
forward.
I understand that, but at the same time, it needs to be looked upon that if the town never had the legal authority to do this, it doesn't seem right that they can charge me $3,000 when I spent $10,000 doing something I never had to do. The town never had the right to enforce it. So, like I said, I don't have a copy of that with me today. And if the magistrate likes, I can bring it another time to show
No,
that?
I think we're going to wrap this up today. You know,
Okay,
it may have, and I'm not familiar with the statute, it may have been a defense way back when, but, you know, we're way past that.
well, like I said, it still comes down to the fact that I'm being charged for something that the town never had the authority to do. And I understand that it's done, and we're past that point, but we're not past the point of these fines. We're not past that point.
Okay.
Can you tell me how much extra time you think the town has spent because of my neighbor as opposed to a normal case?
How much time would
Do you think he wasted 10% of the town's time?
I
Because,
don't believe we've wasted any percent of the council.
well, you guys met with the Lefkowitzes about 4 times. I mean, how many times do you have to meet with somebody to find out that there's something in a 50-foot setback?
Well, first of all, you know, we went out there, they were the ones who made the complaint, they were
Right.
complaining.
Right,
So we always assume when we go out there that there's actually not a valid complaint
right.
and that there is no non-compliance. So Russ went out there to do those inspections first and foremost to see if in fact there was even a complaint.
Sure,
And Mr. McClendon, as it turned out, they had a valid complaint.
I understand that. But you had to meet with him several times, and I'm kind of curious as to why several times.
Well, I'm sure when we were out there meeting with them, that Russ was also doing the inspection of the property. And we would go back out there and re-inspect, there are re-inspections involved. I'll also suggest to you that when this documentation was put together, Mr. McClendon, what you don't see there is all the time that the other town staff people have involved with your case over a year.
I understand that.
I mean, you've had the town manager's time, you've had the town manager's ear, you've had the town clerk's time, you've had the town clerk's ear. You know, that time is not even on here. All you have is my time and my staff's time. So if we want to start splitting hairs here, I'd be more than happy to go back and ask the town manager how much time they also have in this, so that we can drop this down there into the number as well.
We can, but I can assure you it's very minimal. The only time that
I
I spent with
would not
him
assume that.
would be the shade structure issue. But in any case, in light of the fact, like I said, Florida statute clearly says that I should have never moved the bird cages. I should have never moved the shade structure, done anything with it. You know, shame on the town to still be trying to come after me for $3,000, knowing they didn't have the legal authority to do it.
Magistrate Meeting?
Yes.
I understand Mr. McClendon's position. He feels very strongly that the recent change in the Florida statutes, basically makes it a non-starter and he shouldn't be here. However, I will tell you that our town attorney is looking at it. He has talked with county attorneys since the information was brought forward. They are not necessarily in agreement from their legal standpoint, from their opinion at this time. And I understand where Mr. McClendon thinks that may be the case based upon the statute, but it is not a clear slam dunk issue yet. We're still waiting for the attorneys. They're still talking about it. Our town attorney has not given our town council an official position. So I understand, his point of view, and he thinks that it made everything moot, but at this point in time, that's not the case yet.
And the statute number 604.50.
50.
And when did it come into effect?
It came into effect June of 2011, I believe.
Is it 50 or 05? Might be 05.
I believe it's 50, but I could be mistaken. I really would like the magistrate to review that before making a determination on this today. Because as they say, it's not clear, it's very clear, black and white to me. And I think that weighs heavily into how much more the town is going to enforce on me.
Town's response to them?
Bear with me, Mr.
So
Magistrate.
we pulled it up, can't we?
Yes, sir. Hold on. Mr. Magistrate, I am not, first of all, because the town is legally of the opinion that, maybe I should let you
Well,
address this.
I would offer this.
Yeah.
sir, this is your jurisdiction. It's, you know, if Mr. McClendon would like you to take the time and agree to another continuance while you look at the statute and, you know, you provide your opinion, I mean, that's something that you could decide, but again, I would just remind him, that's another hearing, that's additional cost that potentially could get added on to the cost today. So, I mean, it's,
Right, and my concern is that it's being raised late.
Yes.
And the time spent on your case, I mean, we could talk about whether it's excessive or not, but it was spent, you know. And let me just take a moment and look at it. It is .50.
Mr. Magistrate, while you're looking at that, I can excuse the delays real quick.
Yes, you may.
Thank you.
good morning.
Ross, is that the updated version?
I don't have it from me.
It shows a 2011 revision.
Okay.
I don't know when it shows that it's been in some force and effect since 1998.
I'm back.
I have read this section. Let me tell you, I don't have a definite opinion on it. I don't know that it's for me to make the decision for the town in the sense that you have it researched and county attorneys are researching it. My thought generally is that the case has been going on for a year and a half at least, and the town has expended its time on the case. So I don't know that, you know, reading that statute, you know, would change my opinion as to cost. I mean, the town obviously has expended a lot of time. The town has been relatively patient with trying to work with you. And a lot of the time spent on this was due to continuances and things that primarily were requested on the McClendon's behalf, in the sense that there would be additional time to move structures, and that required a continuance. The town generally agreed to continuance, then they had to go back out and inspect. And that happened several times in this case. So, you know, with that in mind, I'll hear whatever else you want to tell me.
All right, a couple things to consider. The law changed after this originally started. The law changed during this case. That's one thing to consider. The second thing to consider is, I understand the town's time and they spent money, but the fact remains they spent time and money that they didn't have the legal authority to do. And to come back and say, well, they spent the time, they should get paid for it, doesn't excuse the fact they didn't have the legal authority to do it. And it's not fair to impose that on me when they didn't have the legal authority to do it. Now, the town manager's already stated they haven't given their legal opinion on it. So, and they've had over a month to look at this, and they haven't done it to give their opinion. So, obviously their opinion isn't what they, probably isn't going to weigh in favor of the town's position, or they would have made that determination already. So most likely when their opinion does come through, it's going to say, hey, the town doesn't have the right to do this. Otherwise, they would have done it already.
Well, that I don't know.
they've had well over a month.
Mr. Magistrate, I'm gonna go on ahead and just, for the record, state that, again, as on behalf of the town of Loxahatchee Groves, we are recommending that you find an order in the amount of $3,172.50 for administrative costs. And Mr. McClendon, I want to remind you of something that has always stuck in the back of my mind since I started working with you. And that is, I had a lengthy conversation with you at the very beginning and onset of this case. I gave you every opportunity to work with us and to try to bring you into compliance as quickly as possible. Do you know, even as of this date, the information that I tried to request from you and get from you to resolve this at the very beginning was never provided to me.
What information was that?
This was the information back when you started indicating that, you know, you were in compliance, you were not in compliance, that you conformed with all the codes, that you had all the information. And this conversation that I'm telling you about is also evidenced by the fact that Mr. Elgin was in my office when it occurred. And we have done nothing but attempt to bring you into compliance as quickly as possible, to work with you, to be able to get you into compliance. And, you know, to some extent, I'm somewhat, I'm just going to go ahead, offended by the fact that you sit here and you want to go through and you want to continue to say to us, well, you know, there was this new law that came into place, and try to take your position behind that new law, when, you know, you had that opportunity last year to do that. I'm in total agreement with what the magistrate has indicated. The time is well gone for us to be having this argument or debate. So again, I'm going to request, Mr. Magistrate, a finding in the amount of $3,000.
Okay, I don't want to debate. I've heard your, anything you want to add? I understand your position on the statute. I think the legal side of that is this. I don't know how that statute would have applied to your case had it been raised, but there have been orders entered that are final and non-appealable, and there's really no way to revisit those. So those orders, finding violations and so forth, are the law, what we would call as lawyers, the law of the case. And now, would have they been different orders had this statute been raised way back when and we had researched it? I don't know. I don't have an answer to that. But that's what's happened, and that's where we are. So I don't know if you want to add anything else, Mr. McClendon?
I just want to say shame on the town, knowing that they don't have the legal authority to impose everything they did against me, to continue on and try and get $3,000 out of me. That's all I have to say.
Okay. Let me do this then. In case number 2010, which in itself gives us an indication of how long this has been going on, 2010-191, I am going to assess as costs the cost expended by the town in this matter. I find that the time expended is reasonable under the circumstances. There's been a lot of work on this case. A lot of time expended on the case was, and I'm not finding fault with Mr. McClendon, but the case went on and on and on with inspections, re-inspections, moved some of the cages, moved more of the cages, issues coming up with Shade House. I think the time expended is reasonable, and I will assess costs in the amount of $3,172.50. So I'll enter an order to that effect. And anything else we need to address on this?
No, sir.
Okay. I will enter an order. Anything else on the agenda that we need to deal with?
Yes, sir. Just quickly, scheduling of next month's meeting, and I'm glad the town manager is here. We have the one case, 277, that we thought would come back next month, but it's going to actually be in October. And the other case we have is Magic Properties that is supposed to come back next month
Right.
in September. And I don't believe that we have anything else that's remotely close. The funny thing is since we've been in the magistrate business, people have taken heed that they're cleaning
Well, it's a good
up.
thing. I mean, that's part of the reason you do it, you know, people pay attention and
Right.
figure there are consequences if they
Right.
don't comply.
So, with that being said, I'm not sure, do we have any idea, do you have any idea where Magic Properties
Yeah,
is?
Magic Properties, actually, they're doing a bang-up job. I talked to the town planner earlier, I guess it was yesterday, and he indicated that they have gone ahead, they have done a site plan, they had to do some traffic studies, I guess, as a result of Palm Beach County, and they're moving forward. We will be getting them scheduled as soon as the town planner has finished his review of the site plan. We will be having them go before the Development Review Committee of the town, and then it would go on to P&Z and on the town council. So, you know, we're probably still looking at least, I'm gonna guess, 3 months. And a conservative, maybe a little faster than that, but it certainly won't be reconciled by the next meeting.
Then if I may make a recommendation that we, again, continue Magic Properties for another 90 days, 3 months.
I'm okay with that, I don't know if we can do that.
Yeah, they're not here, that was my concern, not that they would be pushing for a hearing, but why don't you do this? Why don't you contact them, tell them since they're not completed, the town's in agreement that the matter be continued to whatever date you want to pick.
Okay,
And then just do it by agreement,
yes, okay, yes, sir, we will.
and
I'll call them.
go from there. And if, I guess, for some reason they don't agree, I don't know why they would agree, we'd have to be here in September, but that I can't imagine that happening.
So with that being said, there would not be a hearing in the month of September, and the next scheduled meeting then would be October 17th.
Do you want to go into the details of what we want to do on October 17th?
You missed it. We did that before you got here.
Oh.
Case number 277,
Fantastic.
and the magistrate knows the background
Okay.
and that we're definitive about that date.
Okay.
Okay, so that's a definite date. Nothing else on the agenda?
No, sir.
Okay, we will adjourn. It's about almost 11 o'clock.